And I see Mr. Lopez. I see Madam.
Scheduled for a 6-day valuation trial before you in the middle of October. I think we're supposed to start trial October 19th. The basis of our motion is the following. As the court is well aware, this case has been going on for quite some time. You inherited it from Judge Tudor, much to your pleasure. Case has been pending since 2015, and there's some material developments that took place in this case after you took over, and that's really the substance of our motion. We did receive from opposing counsel the disclosure of the experts that we were very well aware of, Mr. Gary Trugman and Ms. McCarthy, and to give you some context to the relevance of the experts. If Your Honor recalls, this matter was filed in 2015. On or about in December of 2015, our client made an election pursuant to Florida Statute 605.0706 to elect to purchase Aldo DeSorbo's interest in the entity. And as the court may recall, this is a single purpose LLC. It owns a commercial warehouse in Pompano Beach. That it should be a simple case. It should have been a simple case, but it has been anything but that. However, that being said, Judge Tudor, before you came onto the case, Judge Tudor entered a case management order in January of 2016, specifically January 22nd of 2016. And pursuant to that order, the parties were to retain their respective experts. They were supposed to exchange reports back then in 2016, and in fact, they did so. Mr. Trugman and Ms. McCarthy were disclosed, and the parties exchanged reports about the value of this real estate and the LLC. Since that time, as the court's aware, the case has certainly become, at least there's been an attempt by the other side to make things a lot more complicated than they are, and we understand that's their position and that's their right. We continually try to keep the issues focused on the issue before the court, which is the value of this LLC. So when Ms. Bardunius advised me that they may be providing us with some supplemental reports, our presumption was going to be that to the extent that Mr. Trugman or Ms. McCarthy were going to augment their reports in any way, I guess they would try to do that, and we would certainly have the opportunity to certainly object to that and to seek to strike that. Mr. Coward was someone who was identified as an expert witness earlier on in the case, but we never received any sort of report from Mr. Coward. So in other words, we had an affidavit from Mr. Coward. That's all we ever had. And Mr. Coward now has provided us, or we have received a report from him on August 17th. And certainly from our perspective, Your Honor, a couple things. One is it's untimely in the sense that we never received a report from Mr. Coward before August 17th of this year. Yes, was he disclosed as a witness? Yes. Did they provide us with some affidavit from him back in 2019, I believe? Yes, but we never received a report from him. So we think the report clearly is untimely pursuant to Your Honor's pretrial orders. Originally, as Your Honor may recall, your pretrial order requires the disclosure of experts 90 days prior to calendar call. However, we reached an agreement. We agreed that that would be delayed between the parties, and that was okay. What's not okay, Judge, is what we view as a late disclosure of a report. So that's issue number one. More substantively, Judge, here's what the material developments that took place in this case since you inherited the case. One of the issues that took place before Judge Tudor was the plaintiff, Aldo DeSorbo, had filed previously a motion to permit the use of updated expert valuations, which was filed on February 16th of 2018. Judge Tudor deferred at that point because at that point in time, Judge, the court had not yet established a valuation date. In other words, as the court's aware, one of the issues in this case is we got to figure out what the valuation date was. Well, Your Honor actually entered that order, and you entered an order on July 19th, 2019, and you determined that the valuation date in this matter was going to be December 14th, 2015. That's the date. And as the statute works, it's a snapshot. It's to take basically a freeze frame snapshot of that LLC, that entity at that point in time. So more substantively, Judge, we are also seeking to object to any sort of reports relating to damages or valuation post December 14th, 2015. That would not at all be appropriate or germane to the court's analysis. I've seen in their papers that they're suggesting that the court has the opportunity or the right to deviate from the December 14th date as a valuation date, but that's not something that's been argued by them on any new motion for reconsideration in connection with the valuation date. So we have a valuation date of December 14th, 2015. One of the issues in this case, Judge, is that our client maintains and has always maintained that he properly purchased out the interest of the Ventos. And as a result of that acquisition, he became the 67.5% owner of the LLC. Aldo DeSorbo retained his 32.5% ownership interest. So that's an issue that's going to be tried before the court, whether that transaction in fact was done with Aldo's knowledge, with his consent, et cetera. We obviously maintain it was. Everybody understood what was happening in 2012. So the only thing that should be before the court are reports or damages estimates that would relate to any damages prior to December 14th, 2015. What we've seen, though, is that the other side, based on their disclosures and based on their response to this motion, they are certainly going to try to include damages models or arguments relating to damages after December 14th of 2015. That's wholly inappropriate. One of the reasons the statute is set forth the way it is that we all know what we're traveling under as far as a valuation date. After December 14th, 2015, any arguments about damages is irrelevant to the court's analysis. In other words, it's going to confuse the issues, it's going to unnecessarily complicate the issues, and we're going to unnecessarily be distracted with arguments being made by their experts with respect to some variations of damages post December 14th of 2015. The statute operates the way it does. It's certainly a statute that provides for equity, and we certainly want equity in this case. We want to pay fair value to Aldo DeSorbo for whatever his interest is and whatever damages he actually can prove here in this case prior to December 14th, 2015. Anything beyond that is certainly not appropriate under the statute and based on this court's prior orders. And I think it would just simply unnecessarily, number one, prejudice our position clearly. But number two, it's just not consistent with the statute. This is a valuation trial. Obviously, the other side has interjected many other issues, but the issue remains the same. We have a date and time. We should stick to that date and time. Anything beyond that would certainly be inappropriate. And for all those reasons, Your Honor, we would seek to strike Mr. Coward's late disclosure report, which was provided to us on August 17th. And certainly we would seek to prevent any sort of testimony from Mr. Trugman or Ms. McCarthy that would relate to any arguments about damages beyond December 14th of 2015. And I'll defer and try to hold on to about 3 minutes of rebuttal, Your Honor.
Okay, counsel.
Thank you. Let me talk about David Cowherd first. There's absolutely no basis to strike Mr. Cowherd's report because Mr. Cowherd has been disclosed well in conformity with this court's pretrial orders. So Mr. Cowherd was first disclosed in January of 2019, Judge. As Mr. Lopez alluded to, we provided an affidavit of Mr. Cowherd with our opposition to Anthony's motion for summary judgment. And that affidavit talked about how Anthony's version of the facts in this case was entirely inconsistent with ASAP's books and records and stated that Mr. Cowherd had been retained by the plaintiff as an expert in this case. That's back in January 2019, Judge. That was part of the evidence before you when you denied Anthony's motion for summary judgment. In February 2019, in response to expert interrogatories, we provided again Mr. Cowherd's opinions, those in the affidavit, and some additional opinions. We provided his CV and other information that Anthony asked for. So this is well over a year ago now. That was when we were in front of Judge Tudor and scheduled for a trial on Aldo's claims before Judge Tudor. Obviously that changed, and if you fast forward a year to this past June, Judge, we were scheduled for a 2-day valuation trial before you. You might remember we came in front of you for a case management conference in June. And the parties all agreed that Aldo's claims and Anthony's claim were intertwined. There are a number of claims that should therefore all be tried together. And so we jointly asked you for a new trial date with additional trial time. And plaintiff, we specifically asked you for a trial order, Judge, because at the time there was no trial order governing the proceedings. And you entered a new trial order as we requested. And both parties have been operating under that trial order. We updated our expert disclosures, and that includes transforming Mr. Cowherd's prior affidavit and our interrogatory responses all in one place in a report. And they've been operating under that deadline as well, Judge. The same day that we disclosed Mr. Cowherd's report and our witness list, they disclosed their witness list with a new fact witness as well. So that's the timeline that's appropriate. There's absolutely no basis to go back 2 years to prior trial orders. As a matter of fact, if we did, there are trial orders that they didn't comply with that would be a basis for striking their witness list altogether. But there's no basis to do that. And they haven't provided you with a single case that stands for the proposition that it's appropriate to strike an expert witness who's been timely disclosed under the operative trial order. We've provided to you a number of cases, I believe they were uploaded as well, that stand for the proposition that it would be an abuse of discretion to strike an expert witness who has been timely provided in accordance with the trial order. This is a fundamental due process right to litigants to call witnesses and for the court to strike a witness who has been timely disclosed and who the parties have a reasonable expectation will be presented is an error. We've provided to you the Fogel case, the Stewart Agency case, and I believe
Binger.
Aguila Rojas. I'm not sure if I'm pronouncing that correctly.
Well, there's a great case that both sides should look at that goes into great detail out of the fourth. It just came out, I think, in the last month. It could have been 2 months ago, and it goes through all of the excruciating steps that one judge took to avoid, obviously, I realize it's the drastic remedy, blah, blah, blah. And they did allow for the striking of that expert, but it goes through the steps that needed to be taken. That's a brand new case out of the fourth. So anyway, yeah, I'm aware of. Why don't we talk about the deviating from the valuation date, because that's what really is concerning me here. And if in fact the other side wished to take the deposition of Mr. Cowherd based with regards to his report that was just provided, have they requested any dates? Have you provided any dates, and or could you give them dates prior to the trial period?
Absolutely, Judge. They have not requested any dates. They've never actually requested to depose Mr. Cowherd since he was disclosed last year. But if that's something they're interested in, absolutely, Judge. What we had agreed was that if they wanted to serve a rebuttal report, that they could do so within 2 weeks of when we served our new disclosures, but we have not received any rebuttal reports. With respect to Mr. Trugman, he's also an accountant and he's a valuation expert. And so his opinions deal with damages and with valuation. And contrary to what Mr. Lopez continues to tell you, Judge, this is not just a valuation case. That's why we need 6 days. That's why it wasn't tried for 2 days in June. This is a case that involves a number of claims by Aldo against Anthony, against AVL, and we're seeking damages based on those claims. So for example, there's a breach of fiduciary duty claim that Aldo's brought derivatively, and the damages consist in large part of the rent issue that we've talked about in the past. Anthony entered into an unauthorized lease and literally was paying thousands of dollars below market rent to ASAP under this self-serving lease with his company, AVL. We're seeking damages. Damages have nothing to do with the valuation date. Damages aren't limited by the valuation date. damages continue. And so Mr. Trugman has calculated the lost rent up until the date of his report. Those damages claims are pending. They haven't moved for summary judgment. They haven't moved to strike them. There's absolutely no basis to remove them or to prevent Mr. Trugman from testifying about them. Those same rental numbers figure into Mr. Trugman's valuation. Mr. Trugman did value ASAP as of the valuation date that's currently in place, which is back in December 2015. And as part of his valuation, he has equitable adjustments to the numbers, and it depends on what percentage of the membership interest Aldo and Anthony each end up owning. But both valuation experts have incorporated what they include as equitable adjustments. And in the case of Mr. Trugman, those equitable adjustments incorporate rent past the valuation date under the theory that's the subject of many of our affirmative defenses to the valuation, which is that Anthony can't benefit from his own misconduct. And that includes these self-dealing leases, falsifying books and records, failing to move for a stay and apply for the valuation for years while he litigated with the hope of apparently never having to pay any damages. All of these are in our affirmative defenses, Judge.
Okay, so if I could
again,
just,
we're
going way over because it was set for 15 minutes, but just to try to break it down. So you're saying that and correct me if I'm wrong, but as I'm understanding it, are you saying that you agree that on the valuation issue that the expert testimony is going to be for the date of the December 14, 2015 date, that valuation date, but the experts are also going to be testifying with regards to the affirmative defenses and claims brought with regards to the under renting it, so to speak, or lower payment than it should be, and those go beyond the valuation date. But as to the valuation, there's going to be testimony only as to that valuation date.
Well, Judge, for Mr. Trugman, the valuation date is the valuation date we've set, but we argue that the equitable adjustments go beyond that date. So I'm not sure how that fits into what you're just saying. I just want to make sure.
Okay, so when you're saying the equitable adjustments, are you talking about the failure to charge appropriate rent? Is that what you're talking about when you say the equitable adjustments? Because I'm trying to understand what exactly that means.
Yes, Judge, but maybe I can answer it more broadly because Ms. McCarthy, our appraiser, is involved also, and she has appraised the building, which is incorporated into the valuation as of the valuation date and also later dates. And we have affirmative defenses based on that as well, Judge, because when you did this valuation date, that was before Anthony had ever even filed his application for evaluation, and it was without any evidence being heard. So our affirmative defenses include also that the evidence about this individual case should be heard and the valuation date reconsidered in light of that, because they had not even applied for a valuation at the time that the initial valuation date was entered. And again, they haven't moved to strike the affirmative defenses. There's no hearing on them. So the way the pleadings stand now, all of these damages claims and affirmative defenses are out there. They relate to the valuation as of a certain date, including incorporating the rent into that valuation, regardless of when it occurred. With Ms. McCarthy, it does include specifically later dates if you reconsider the valuation date, but we think all of it needs to be deferred at this time because all of those defenses are out there.
Didn't the valuation date already go up on appeal?
The valuation date was subject to a cert petition, Judge, in which the appeals court only found that it was not, it did not address the merits. The court just found that there was no jurisdiction to address it because it was not an issue that could not be remedied on appeal, essentially.
Oh. All right, Mr. Lopez, real brief, because I got to move on. I've got several others behind you.
Very, very briefly, Judge, I think you hit the nail on the head. What we're just concerned with is what I heard Ms. Bardinas talk about, which is if it's just about under market rent beyond.
That's it. That's the word I was looking for.
Yeah, under market. I knew you were struggling for it, but I didn't want to interrupt. So if that's the issue, we're okay with dealing with that issue. That's fair. But what's not fair is to try to go beyond December 14th, 2015 for the upward adjustment that they tried to include in their supplemental reports of Mr. Trugman and Ms. McCarthy. And that was something that Judge Tudor deferred on until the valuation date was fixed. We now have that date fixed. So all we want, Judge, we want a fair playing field for trial, which is, as far as Mr. Cowherd, I heard you loud and clear. We'll either decide to take his deposition and or we will provide a rebuttal report within the next 2 weeks if we so choose to his report, since I understand the court's probably not going to strike his report. However, we just want to make sure it's clear pursuant to the order we're seeking today is that as far as the valuation of the property, meaning the LLC and the real estate, that the date is December 14, 2015. Any upward adjustments which they seek to include evidence of should not be considered by the court. Damages is separate from that because that's under market rent. That's an argument out there. But other than that, they shouldn't be allowed to introduce more evidence of upward adjustment of the value of the property. And that's what we're concerned with based on the supplemental reports we saw.
Okay, and counsel as well, I know that you're saying that you're concerned and you felt that appellate review or something with regards to the valuation date. So my advice would be to proffer the evidence at that time, but I made the valuation determination a long time ago, and what I don't want to do is have a trial within another trial. We've already, the determination has been made as to the valuation date. If you wish to proffer additional evidence as to additional dates that the court should have chosen, you may do that as a proffer.
Okay, to clarify then, Judge, I understand that would preclude Ms. McCarthy's later appraisals of the property, but it would not exclude anything that Mr. Trugman is currently opining about, which incorporates the numbers through the time of his opinion, both as damages and as equitable adjustments to the 2015 valuation.
Again, I think we're all clear on this at this point in time, at least my ruling. I understand what you're saying with regards of the rent issue and so forth, going beyond the valuation date. And with regards to the value of the building property itself, what I want to do is I want to stick to that valuation date. But since you're saying that you believe that the court should have considered additional valuation dates, or that it should be a different valuation dates, if you wish to proffer that evidence, you may do so.
Okay, but that's just as to the building as opposed to the entire valuation process.
When you say the entire valuation process, again, you said that this equity claims issue, and I'm saying I understand your argument with regards to the equity claim, but the valuation as to the building, that the very simple issue that we've been trying to, narrow down to on this is the December 14, 2015. I don't know how many different ways to say it.
Well, I guess what I'm just trying to figure out, since you'll ask us to draft an order, Judge, is are you striking all of the affirmative defenses and striking Mr. Trugman's opinions, even though they're based on a valuation date? That's the same valuation date that you've, I understand for the appraisal. I'm just trying to figure out for Mr. Trugman whether there's any limitation on his opinions, which include damages.
No, I think I don't, strike all your affirmative defenses. I'm not here on that this morning. I think you're going way beyond the two issues that we've discussed here this morning, just as this case is just exploded essentially since it was moved into Division 25. And once again, we're talking about things that are way out of the realm that have been discussed. I'm saying you made the argument that the damages, like the underpayment of the rent, I said that could go beyond the valuation date. But when we're talking about the building itself and the valuation of the building, the property, and so forth, that was the December 14, 2015. I don't know how to say it any clearer or more succinct than that. As far as striking all of Mr. Troy, I never made any of those comments. So you're putting words in my mouth that I haven't even come close to saying.
Okay, thank you, Judge.
In the court's ruling, we will endeavor to prepare an order, and hopefully we'll work out agreed language and a proposed order we can submit to you later this afternoon or tomorrow.
All right, thank you so much. And if you all can't agree on language of the order, then you can also, in the alternative, make the transcript the order as well, because certainly maybe I'm not explaining it well enough, ordering it, ruling well enough. But what I'm saying is I'm looking at a very short motion that was presented to the court and the response to that motion. And it deals with essentially the valuation of the property and then the reports, which included valuation, not valuation amounts, but amounts doing with the equitable claims. One of them we've discussed here this morning being the underpayment of rent over a period of time. Okay?
All right, Your Honor. Thank you very much.
Judge.
Have a great day.